and welcome to the second installment of the Brazilian Constitution in a Nutshell. This is a short series about the Brazilian Constitution presented by Professor Vanice Valle. My name is Nadia, I'm a legal researcher, and Professor Vanice has a master's and a doctorate's degree in human rights. She is a visiting fellow at Harvard's Human Rights Program, and she has a postdoctorate's degree in human rights as well, and is a professor at Universidade de Estácio de Sá. Professor, in the first installment, we talked about the history of the Brazilian Constitution and started talking about the presence of human rights in the Brazilian Constitution. Can you give us a little bit of a resume of what we were talking about?
Yeah, sure. In the last episode, we were talking about the Brazilian Constitution history, how the National Constituent Assembly was summoned and how the deliberation was held at the occasion. And one thing that I have already pointed is the fact that the Brazilian Constitution has a huge list of human rights. You should take into account that the Brazilian Constitution intended to be a transformational one. The idea at the time was not only to consolidate a democratic ambience, but also to provide through the Constitution a transformation in the Brazilian society in which you can find a lot of inequality, thinking about social development and the economics. So the Constitution was enacted with a list that would bring something about 70 different constitutional clauses related with human rights. You will find constitutional clauses that grant human rights of the first dimension or generation, the liberty rights, but you will also find a lot of socioeconomic rights. And this system is all provided with immediate application, which is also a literal clause in the Brazilian Constitution. So this is the framework that came in October the 5th in 1988 when the Brazilian Constitution was enacted.
And what does this clause of immediate application mean for the human rights inscribed in the Brazilian Constitution?
A clause of immediate application is not a particular feature of the Brazilian Constitution. You will find clauses like this in the South African Constitution, for instance, or in the Colombian Constitution. The thing that ran differently in Brazil was the fact that in order to enforce the transformational project, the interpretation of that clause was not only about application. When you think of application, you're thinking about incidents, about the real usage of a legal clause at a certain moment. What happened in Brazil was the fact that courts and even scholars started to read that constitutional clause as immediate efficacy. And you have an important difference when you think about immediate efficacy, because you mean not only that the clause is applicable at the moment, but you will involve an idea of the degree of application. When you think about efficacy, it's not only a right that can be granted at the moment, but should be granted in the broadest range of protection and efficacy itself, so that the turning in the interpretation, turning the literal letter of the Constitution, which mentioned immediate application, into immediate efficacy, brings a pressure, a tension, an idea that all those rights that compete among themselves should be granted at the highest point of efficacy. And this created a very complex idea of how you can draw public policies and how people can require or claim their own rights into the judiciary.
You said that there are around 70 human rights inscribed in the Brazilian Constitution. Are they outlined or are they very detailed in the constitutional text? And if they're not detailed, how does the decision about the content of the right and how the right should be enforced come about?
they're not very detailed, and this is how human rights are supposed to be brought into a constitution. So they're announced as a general clause. For instance, you have in Article 6 in the Brazilian Constitution a right to housing, a right to transportation, a right to leisure, a bunch of human rights. Bringing them into the Constitution as general clauses proposes the question of who is supposed to draw the lines about those rights' content. So, who are the destinatary of those rights? What are the real obligations that come to the government considering those rights? These are things that are not detailed in the Constitution, and sometimes are not detailed even in the different levels of the Brazilian government. So the indeterminacy of those rights also brings a lot of tension, because when you think about a right to housing, for instance, you can understand it as a right to property, as a right to shelter, as a right to something in between. And that kind of discussion is very relevant and is very present in the litigation around a right to housing in Brazil.
Professor, you talked about litigation in the subject of human rights. Can you talk about the framework for this in the Brazilian Constitution? Is there the provision of class actions, or what are the procedural elements for that? And also talk about the current state of litigation in human rights in Brazil.
Sure. We do have class actions in Brazil, but they're not quite the same as they are in the States. For instance, a judge cannot turn an individual lawsuit into a class action. The lawsuit should begin as a class action. You can think about as public interest litigation would be the better analogy. We do have a lot of litigation around human rights in Brazil, but they will usually be taken through individual lawsuits. And this is related with cultural reasons. People usually think that the judge will easily provide some sort of provisional decision through an individual litigation because the repercussion will not be that big or that significant than he will do in a class action. The litigation related with human rights started in the mid-90s, when the Constitution was already settled as capable of granting a democratic ambience. Then we had, at the mid-90s, we had a huge crisis in the public health system. Brazil has a very broad public health system, and people were really dying because things were a mess in that health system. And at the time, considering that was a real menace, the judges overcome the barrier of the non-intervention in the public administration or in the public policies, because the result might be death. And once you overcome that barrier, it becomes a little bit easier for a judge to be activist and to decide that this or that human right should be granted or is not being enforced the way it should be. So nowadays we have something around 130 million lawsuits, taking into consideration that the Brazilian population is something around 210 inhabitants. So we have 130 lawsuits, many of them related with human rights. This might sound as something possible or something relevant, something interesting, but as a matter of fact, it is not. Because considering the fact that those human rights compete among themselves, having such level of judicialization brings some sort of dislocation of the debate about the degree of enforcement of human rights from the political arena into the judicial arena. And this is not quite what a democratic ambience will require. So the experience is not very successful because people are reaching human rights protection according to their ability to go to the courts and file a lawsuit. So this is not a very good outcome from the Brazilian constitutional framework.
This whole discussion in the judicialization of human rights and the individuals seeking their own even agendas in this matter seems very intricate, very complex. Do you have any reading material that you could suggest for our viewers to?
Yeah, sure. I have a recent article that was published in the Tulane Journal of International and Comparative Law, and you can also find some more material in the SSRN page discussing that judicialization matter in the socioeconomic rights in Brazil.
Perfect. I think that wraps up for human rights.
Yeah, for the moment, sure.
And what is the subject of our next installment?
In the next installment, we're going to be discussing the Brazilian constitutional amendment process. Our constitution is reaching 30 years old, and we're also reaching the mark of 100 constitutional amendments. So this is also a very different experience that I want to share with you that are watching the Brazilian constitution in a nutshell.
Oh, thank you very much, Professor. Thank you guys for watching, and don't forget to subscribe to her channel and click the notification bell so you can get the notifications whenever she posts new stuff. Thank you, Professor.
Thank you. See you then.